It is 6 o'clock. All right. So what we will do is open the public hearing to discuss the Forter issue, which is a short-term rental in the town that has not complied with our previous or current ordinance regarding short-term rentals. Today is Thursday, June 29th. As part of the process tonight, if there's comments from the public, we'll give them an opportunity to speak. What we will do to start this off, as we know that Mr. Fortner is not going to attend, we are going to replay the comments that he made at our June 19th town board meeting. We have the video of that up there, so when we get ready, we'll share that just to give you all a refresher as to what their thoughts were since they couldn't join us this evening. As you know, it's been 2 years that they have gone since notification without any permits, including dat cap and tourism. They did have a tourism zone permit, but they did not have a town permit. Also, as you'll see from all of your reading that you had from the 19th board meeting, there's also a copy of the cease and desist letter that was sent by our town attorney, Amy Sullivan, to tell them that they had to cease with the rentals, which they have done. So we'll watch the video, and then I'm going to ask Amy, who did most all of the correspondence back and forth with these people, to kind of recap the history, as much of it is well documented, which you all have copies of. So who's controlling that? You,
I
Amy?
am.
So let's just replay that piece. You might want to turn those lights off there. Can you see that all right?
Is it up there?
Thank you.
Well, I appreciate that because we are working in Canada for a few years. Not my plan, but that's the way the life takes you. So I just wanted to say a few things. Really, appreciate the communication from Amy. For my wife and I think fundamentally for the board, we had no intention to violate the ordinance. And we've been away for a few years in Canada. It's been actually 4.5 years. I've got a 4-year anniversary in my company just a few days ago. So when this started, we were not getting mail. So the mail I know there were letters sent to the house about hearings and questions and the ordinance. We did not receive it. So there was a gap in communication. And part of that's our fault, to be honestly. We had, over the years, we didn't receive any mail at the house that was really needed. And so initially when we moved to Canada, we forwarded our mail, but then we stopped after 6 months. So there's a bit of a gap on our end. And so by the time we caught up with this, obviously things had changed and the ordinance was approved. Things had been in play for a while. So it was a bit of a catch-up for us. Also, Lundquist was our property manager, and we rented the house, I think, for 4 seasons maybe. And Lundquist, when we first started renting, they guided us through the process to get a license, water testing, and so forth. And we assumed that they would keep records, and if there's something we needed for that season or for the next year, they would notify us. I guess that's my mistake. They didn't do any of that. So they listed the property and took a handsome commission. And just to be brief, on our end, we've discontinued our rental operations. It's not beneficial to us as owners, quite frankly. It benefits the community more than it does us. And if you sit down and do the math, our only intent was ever to help maintain the property. It's our home, and we're working away for a while. We just wanted it to be lived in and maintained. That was all. So we've stopped rental operations. Lundquist has ejected us from their website and the business, and we are owner occupied going forward. So since we're working away, the house will generally be empty other than, when we're here for vacations or long weekends, that kind of thing. So my request is, we're not going to apply for a permit to rent. We're going to leave the house empty going forward and just maintain it ourselves. And so my request is if we can, we would accept a denial of the ability to rent in lieu of a fine if that's acceptable to the board. But, like I said, we had no intent to violate ordinances. That was not our wish or desire to kind of circumvent any rules.
Okay.
All right?
Good enough, thank you much. All right. So the key ingredients from that conversation, they are not renting any further. They expected their mail to be forwarded, no idea why or why not. Lundquist, their rental agent, apparently, at least they feel, did not leave them in the best of shape with respect to the responsibilities they had as a landowner, property owner. What I'd like to do is switch over to Amy for a few minutes and let her detail with you the conversations that she's had and what she has documented. And then we will have a discussion and any input from anyone here tonight. So, Amy?
So we initially contacted all of the short-term rentals in November 2021 after the initial short-term rental ordinance was passed. And all of those short-term rentals were contacted via mail. So all of those were contacted, and then again, we contacted everyone in April of 2022. The initial contact in November 2021 was if they planned to rent from November 2021 up until June 30th, 2022. If they didn't plan on renting between that time, they didn't necessarily need a short-term rental license. Then starting, obviously July 2022, those short-term rentals needed a license. So to kind of start that season in April 2022, I reached out to, again, all of those short-term rentals via mail because obviously they were going to need license going forward. So we did that. The ones that did not apply were then contacted again in August. So I reached out to the forwarders or their platform by making a fake reservation, as you can only reach out to that owner when you make that reservation, because they won't let you message the owner until you make a reservation. So Lundquist reached out to the owners and had them contact me, and that's the way we started a conversation between the owner and myself. And so that's the way we initially started the process of potentially getting them a license, and that was August of 2022. We went back and forth. They seemed to start the process of getting a license, or they just started asking random questions, as in, you know, how would I go about, where would I go to seek the sanitary permit, and how would I know what my occupancy was? But there was really no follow through when you, obviously there was no follow through because we didn't get anything as far as the actual application. So fast forward with everything else, it fell through the cracks. I will be the one to say that I didn't catch it. It fell through the cracks until going back through everything and this spring. And I'm like, they didn't have a license. And so again, I followed up after we had we started the process again with updating the STR ordinance. And again, I did it the same way, reached out, made a fake reservation, reached out to Lundquist. Lundquist was very shocked that I'm reaching out to them again, that they didn't have a license, and so reached out to them, and again, I was put in touch with Tricia, and we had a conversation about it, and it seemed that she had known about what the town of Sevastopol was working on as far as the new ordinance, or the amended ordinance, I should say, and commented about that and how we were considering passing the owner occupied. So I had stated that, yes, the town had passed that as of April 17th. Then a cease and desist order did go out, as the chairman had mentioned, to the Forders on April 19th, 2023. Our attorney issued that. They then had come into my office on May 25th and asked, what they can do to rectify this. And I asked at that moment in time, had they read their cease and desist order, because their advertisement was still up on the web. They said they did, and I said, well, the first step would be taking that advertisement down. They said they could do it that day, which they did. Their nightly charge is $335 per night. Their weekly charge is $2,100. In 2022, and these are all numbers that I did get from Lundquist, so they are all accurate. In 2022, their occupancy that they were advertising was 10. Their Pouts occupancy is 8. So they had been advertising occupancy of 10 this whole time. Just keep that in the back of your head. So in 2022, the nights that were over occupancy, July 23rd through July 30th, they had 8 guests. July 16th through the 23rd, they had 8. So they're going back and forth here. So per our ordinance, the town has, so they had, let's see, they had 7 nights over occupancy. And our ordinance, per our ordinance, the town has the ability to impose a forfeiture of not less than $100, no more than $1,000, plus the applicable surcharges, assessments, and costs, including the attorney's fees for each violation. Each day the violation exists or continues, and that is each day, it constitutes a separate offense under the ordinance. I do need to mention, though, that the Forders did not have a DAT cap license for the year 2022. As soon as Lundquist realized all of this, they dropped them as clients because they were unaware that all of this was happening. So those are the facts that were all taken into consideration in bringing this forward.
Okay, thank you, Amy. Want to address one comment that you made where you said it fell through the cracks. It did not fall through the cracks, and that's a misstatement, because it is not our job nor your responsibility to do the follow-up. So what we have done is a courtesy to try and prevent problems, but it is absolutely not our role or responsibility to take those actions other than the normal notification process. The expectation is that the owner has to follow through, and there certainly were written communications back and forth between the owner and yourself, indicating that they knew there was an ordinance out there, that they started to take action to acquire a permit and DAT cap license and parking, etc., and they did not follow through. And that, of course, continued on into 2023. So just wanted to clarify that.
Okay.
Before we move on to any discussion, is there any comments from the audience? Hearing none? All right. So really this evening, I don't think we have any choice but to consider a forfeiture as a result of their actions. I think it would be extremely unfair to the people that we've dealt with in the past and to any future short-term rental owners to not levy the appropriate fine given the actions that they've taken. Although they may have felt, for whatever reason, that their mail did not get forwarded, their property manager didn't do their role or their job, et cetera, and the fact that they're not going to rent in the future, irrespective of all of that, I think it's our job to fine them for the lack of follow-through on the ordinance. So, my two comments, Amy's, you, as Amy indicated, the fines are per day. So there's a lot of latitude there in terms of where we're at. But given the serious nature of the lack of action that they've taken, it should be, I think, fairly significant. So, your comments. Whoever would like. Linda?
So if they indicated that they were not receiving their mail and/or email, were they also not receiving their rentals, less commission and other, obviously somebody must have been doing the reporting to the tourism zone and somebody must have been remitting their share to them. So I fail to see that if they're saying they're not getting their mail, now understanding it could be auto deposit too to a bank account, but you would think once you got your statement, you would see that, oh, I'm renting and I'm receiving income, so I need to comply with our clerk's request and also the request to obtain a DATCAP license. So.
Dan?
Yes.
Did he actually say that they didn't receive emails? I only heard mail.
He just said mail forwarding. I think they
Mail,
received
not
emails
emails.
because we have a history of
Yeah.
that between
So
Amy.
they,
Okay, I'll retract emails, but
Right.
he did state that he had not been receiving his mail.
right,
Right.
but email is,
And still, if it expired or didn't expire, if you're any normal person, you're going to ask for your mail, wondering what happened. Why aren't I getting any mail? But he did mention in the statement that Lundquist charged him a healthy fee. So obviously they were getting paid, or they would not have had any fees. So who knows? Any other comments from anyone?
I just wanted to say that it's a substantial number of nights. I roughly added them up for 2021, 22, and 23. I can't find my note here with the total, but I want to say it was like, I don't know, 300?
Well, some of it is exempt nights, so you have to exclude those. The exempt
Why
nights
are
are
they-
30 night
Oh,
rentals.
30-night stays, okay.
And we've looked at that and taken that into consideration in terms of where we're going.
Looking at the report from the tourism zone on page 33 of our packet, that's what rented nights, I just roughly added those up and came up with about 300
Right.
or so.
Mark, Derek, comments?
Well, where does Lundquist fall into this? Where is the liability in any of this?
I don't think there's anything in our ordinance that talks about the rental agent
We
being
talk
responsible.
about these rental agencies in our ordinance all the time. But, they knowingly were renting it out illegally the whole time with the pouts especially.
I think,
So we need to start making them liable for some of this as well.
and in the conversation I had with our town attorney, she did indicate that we would have some, if we decided to go that route, we could. I think realistically, what's going to happen is that the owners are probably going to have to go back to Lundquist and deal with that issue. Whether it's valid or not, I don't know, but,
But I think part of our responsibility that we have that in here, that these rental agencies have to be part of our ordinance, that we need to hold them accountable as well. That's my thought, because, and I'm not saying the owners weren't in the wrong, obviously, that, whatever. But these agencies, they're still making a healthy fee, and they have to know what's going on.
and I'm sure that if you went to Lundquist today, they'd ask you, if you rented, do you have a dad cap permit? Oh, may I see it? And do you have a, you know?
Yeah.
But you're right, they should have known that ahead of time.
Well, and where's your license through your municipality?
Right.
But they, again, are they, is there anything in our ordinance that said they're responsible? I don't think so, is there?
It doesn't say they're responsible, they're saying that's one of the ways they can rent. You know, it says in there, they have an agency, so.
Well, if you look at their application through the zone, they signed it. The onus is on the owners. Yes, I believe the rental agents should, you know, maybe walk them through that. Oh, by the way, you need a DAT cap license, you need this, but basically it comes down to the onus. It is their responsibility, the owners, to follow through with all of the requirements. And like I said, their names are on the application, so.
Amy, did Amy Sullivan give us the attorney fees yet? She was mentioned.
She has not.
Okay, so we have to add that to whatever we decide. You know, if you take a look, and you need to look at the ordinance as well, but if you take a look at the nights that we had over occupancy, and the fee for that can be $1,000 a night, and we can step that up, there's a substantial portion or a substantial fine in that area alone. And the fact that they had no license in 2022, rented it 5 times as a rental. Again, this is after she's been told she needs the permit.
You mean as far as there was actually email communication or
Right.
some kind of communication?
Right. And that's in there.
So she can't deny that.
Mr. Chairman?
Yes.
Okay, you said they only rented how many nights in 22? Because again, if you look at page 33, there's
You have to take out the exempt nights. You'll look underneath the column. I think I got the same sheet.
Oh, exempt sales? Is that
Yes,
what we're
under
looking?
exempt sales,
oh, got you.
Okay, you have to
All right,
back
got
those
it.
out.
Back those out, okay.
because those are monthly rentals. And as you'll see, as you look down the column, you'll see where it's like $32.50, $32.50, so on and so forth. So that's a full month rental, falls outside
Okay.
the scope,
Yep.
but still inside of what
1, 2,
Amy and was able to put together. You had 7 nights over occupancy.
Yep.
4 stays before the warning of August of 22 at $1,000 a stay. So you'd have $4,000 there.
Plus the 7 over.
Plus you have 3 stays after the warning in August. So you have the ability to double that based on the standard that we've done with Amy Sullivan and with the Coulter Johns. So you'd have another $6,000. So just for the basic starting point, you'd have $10,000 fine. And then no license, and they rented it as a short term 5 times. That could be $1,500 a time, so that could be another $7,500. So you could have $17,000, $18,000 plus attorney fees, plus we can also, if we decide, we can charge them for the lack of license, or for the license fee, which would be another $550 for the 2 years.
Where are you getting those numbers from, Dan, for the 1500s and the?
It's out of the ordinance.
Could you just recap again?
If you look
Number
under
of
fines and
violations
forfeitures.
for over occupancy,
I don't
number
see
of
$1,500
violations in
anyway.
2022
Anywhere in
and 2021.
100,000.
And how you come up with your total of 18,000.
Right, so it can
Okay.
be anywhere from
It's-
100
Please, yep. Talking into the
to
microphone.
1,000.
It's all right, I'm gonna wait. Amy,
Yeah, I don't see a 1500 on there anywhere.
go through your sheet on occupancy, nights over occupancy, but then, excuse me,
Go through my,
the fine component, what we roughly calculated.
what we roughly calculated.
Okay.
So you had 7 nights,
Nights 7 over occupancy.
7 over
Okay.
occupancy, 4 stays were before the warning in August 2022. So if we're taking the scale of, if we're following the scale of kind of what Amy Sullivan set forth in before with the previous one, the first tier, let's say, was $1,000 per, let's say, the first tier, okay, so the first time. So we'll say $1,000. So we have
Times-
4 of those, so
times
$4,000,
four.
let's say.
Okay,
And then we had 3 stays after the warning. So let's say that those 3 stays, now let's bump that up to $2,000 because now they had the warning
each.
So now that warning is now $2,000. So now we have so we have $4,000 and now $6,000. So now that's $10,000, okay? And so that's just the over occupancy
Yep.
part, okay? So now we're gonna take that, no license in 2022. So they rented 5 times as a short-term rental, okay? So that's pretty much all we can say. That's the amount of times. Now, you could say,
Each
you could-
violation,
each violation, you could say days,
right?
or you could say times. I mean, you could say whatever you wanted to say. If you say times, you're being very nice, you're being very kind. You could say days. So, you're being kind by saying times. So if you say, they rented 5 times at, let's say, $1,500, which you could be saying 5 days at $1,000 apiece, but you're saying times, well, that would be $7,500.
Okay,
And I'm just throwing these numbers out there. These numbers don't have to be what they are. So if you took those 2 numbers and added them up, that would be 17,500.
17,500.
Now, Dan was saying, well, you could also add that they didn't even apply for those licenses. You could also add that those licenses could also be added on as a forfeiture as well.
The annual fee.
The-
are $350.
Right, so you could-
300 and 250.
300 and then the 250 because they would have 2022 plus a 2023. So that would be 300 plus an additional 250. So 550. So then that would bring it up to 18,
1,050.
yep, 18,050.
Okay, that makes sense, thank you.
Yep,
Plus costs and attorney's fees, publication, et
plus,
cetera,
yep.
et cetera.
Yep, that would be added onto that as well.
So, I mean, you could, obviously, you could go to an extreme situation, which I don't think we want to, and that's not our goal.
No,
So, but it could be as much as $1,000 a day, and you could calculate that off of every stay that they've had. You'd be in the $40,000 to $50,000 range, which is a little over the top. I think it's more than anybody would need a message to deliver. So,
Were there any complaints on this property via Granicus?
I do not know. Do you know?
no, there were no complaints via Granicus.
So we have to decide, we're going to fine them, I assume, and what's the amount? Need agreement on that, any discussion that you want to have, up or down?
Just like you indicated before, considering fairness in the previous case, we've stated the numbers, and I would say it's 18,050,
Plus attorney fees.
plus attorney's fees, publication fees,
Fees.
and any other costs that we may have incurred.
Any other comments? I don't know who that was.
Well, just sadly, nobody, this board doesn't want to do this. I mean, we would like just people to follow the ordinance. You know, it's that simple, that we don't want to be doing this. And it's unfortunate, and
Well, we need to take some action, so
rules need to be enforced.
Can we take formal action tonight?
Yes.
Is that everything?
yep.
Okay.
So we would need to take a motion to decide to fine them and what the amount would be. And then we would add that, the miscellaneous fees to that number. So,
Well, I guess I would make a motion that based on the information provided to the board and the previous communications between our clerk and the Forders and their non-compliance, that we recommend a fine of, let's see, $1,000 for 4 nights of violation or occupancy. And again, 3 stays after the warning of over occupancy at $2,000 each. So that's $4,000 plus $6,000. And no license granted in 2022 for 5 nights at $1,500 would be $7,500. Plus the 2021 license fee of $300, plus the 2022 renewal license fee, which would have been $250, for a total of $18,050, plus any out-of-pocket costs such as publication, notice, or whatever, and our legal fees.
okay, we have a motion by Linda.
I'll second that.
Motion by Linda, second by Jeannie. For forfeiture of approximately $18,000 plus miscellaneous fees for the Forders. We have a motion on the floor. Is there any further discussion?
I don't understand where the $2,000 and $1,500, I don't see it in here.
The difference is, the issue is, I shouldn't say the issue, you have the ability to charge for $1,000 a day for each violation. So if
I
we
understand
went-
that.
Okay, so if we decided to do that, we could.
I understand
increase
that,
this.
but when you say 3 nights at 2,000 and this.
So what we're
at
doing is
1,500,
when someone's ignored what's going on, we've increased the amount. So rather than charge $1,500 or $1,000 for
But that
that
doesn't
day.
go to the letter of the law of the ordinance. It says $100 to $1,000 is what I see in the.
Per
the
day.
ordinance. Well, I know that, but still, we
So
can't.
if I either.
So
go
to
ahead.
me, the way she worded it is incorrect, because we say 3 nights at 1,500 and 4 nights at,
It should have been stays, not
Stays.
nights. It was stays. So
Okay.
when Linda made her motion, I should have corrected. You're right, it's
Okay.
stays, not
Stays and
nights.
not nights.
okay.
Okay, sorry.
Because it's not exactly how it's worded in the ordinance.
It's
No,
noted.
I got you. You're right. It was, she
Stays
mentioned
and not
nights
per
and I
nights.
didn't catch it.
Okay.
So,
Thank you.
okay. Anything else, Derek? You're okay?
Yep.
All right. So we have a motion from Linda, second by Jeannie. All those in favor signify by saying aye.
Aye.
Opposed? Motion carried. The clerk will take the necessary steps to inform them, and the meeting, our hearing is closed. So, thank you.